Hello everyone, my name is Kyla and today I will be discussing land reform. Tax tweaks examine whether our current framework for land ownership and registration remain effective for the need of the 21st century. In this presentation, I will cover the distinction between unregistered and registered land regime, including the origin and history of this system, pertinent classification of interest, and the Legislative Reform 2002. Also, an explanation of the mirror principle and its relationship with other principles. And finally, a critical assessment of the practicality of the mirror principle, followed by suggested reforms to enhance the efficiency and transparency of land registration. Historically, ownership of land was rooted in common law principle based on possession. So before formal registration system were established, ownership claims depend on physical possession and existing deeds. Relevant case laws such as Pine and Granham in 2002 illustrate that long-term possession could result in ownership claim. However, in the late 19th and early 20th century, we saw a movement towards land registration to address ambiguity in ownership. The torrent system pioneered in Australia influenced the UK system and became a model for the Land Transfer Act in 1897, initiating a compulsory registration in London. So if we take a critical look at the history of land registration, the Land Registration Act 1925 marked a transition towards a comprehensive registration system in England and Wales, creating a unified framework, while the modern developments like the Land Registration Act 2002 aim to simplify the modernized existing system, emphasizing registration of title rather than mere deeds. The Land Registration Act established clear classification of interests in land, the registrable interest and the overriding interest. The registrable interests include the legal estates such as freeholds and leases, along with registerable charges like mortgages, while overriding interest can bind purchasers without being registered, relying on rights that may not appear on the register, such as easements and short leases. The critical case of Williams, Glenbank Limited and Boland demonstrates how equitable rights can affect ownership even if they are unregistered. Part of the registered land system is the mirror principle, which is rooted in Section 1 of the Land Registration Act 2002. This posits that the land register should accurately reflect the owners. The key attributes of the mirror principle are transparency, meaning it provides a clear picture of ownership, allowing buyers and lenders to make informed decisions of who owns the land, and also legal certainty. It offers assurance based on the record information on the registered, aligning with Section 1 and Section 58 of the Land Registration Act 2002, which states that registration confers title. Simply put, what rights and restrictions exist over that land. However, if the register does not reflect the true state of affairs, this undermines the entire purpose of the system, leading to potential conflicts and uncertainties. In conjunction with the mirror principle, we have the Cotton principle and the insurance principle. The Cotton principle complements the mirror principle by asserting that certain rights that exist over the land, specifically equitable interest, are not visible on the register. These concealed rights remain behind the contents and can still bind the purchasers. So in Section 29 of the Land Registration Act 2002, it outlined this principle, stating that all certain interests are offensible against third parties who acquire registered title. For instance, in the case of Foy, the court upheld the interest of an individual who was in occupation of a property, illustrating how interest can bind purchasers unexpectedly. The idea here is to protect the register simplicity by not cluttering it with mirrored equitable claims. But however, this also complicates the application of the mirror principle, as buyer could be unaware of existing equitable claims. And next is the insurance principle. The insurance principle is evident in Section 103 of the Land Registration Act 2002, which stipulates that the state provides compensation for losses resulting from mistakes made in the register. Though the insurance principle attempts to build confidence in the reliability of the land register, it also raises questions about the accountability and the extent of the state obligation, particularly when landowners face losses due to unregistered interest or issues arising from the Cotton principle. So despite the foundational role of the mirror principle, its practical application raises several significant challenges. The first is unregistered land. The complexities surrounding unregistered land were highlighted in Land Commission reports on land registration. Landowners of unregistered plots face challenges proving their ownership, which complicates transaction and deter potential buyers. Approximately, as we already know, 10% of land in England and Wales remain unregistered. These include complex properties where transactions hinge on title deeds rather than on straightforward comprehensive register. For example, if we consider the Land Registration Act 2002, Section 4, which mandates that all land transactions be registered after a specific time frame. Not many owners can do this, and owners fail to register, leading to potential conflicting claims and lack of transparency. The reports by the Law Commission have highlighted the disadvantages of unregistered land, which complicates the land registration system significantly. This situation can lead to ambiguous ownership claim. Transaction involving unregistered land can give rise to complex disputes where ownership is unclear. In the case of Williams and Glenn, Lord Salmon expresses frustration with the requirement to demonstrate a good root of title. Cases like Allan and Roughly in 1955 illustrate the challenges of establishing rightful owners without the title registration. And also in the case of Lloyds Bank and Carrick, the court concluded that the lack of registration meant that an unregistered contract did not convey the legal estate of the property. Lord Justice Moritz remarked that if the land had been registered, the result of the case will have been quite different. Thus, the act of registration can profoundly affect the right of properties of parties involved. And another issue is overriding interest. The LRA 2002 clarified the definition of overriding interest. Overriding interests such as short leases or rights of occupation are encapsulated in Schedule 1 and 3 of the Act, thus substantially enhancing the predictability of land rights. So if we look at the case of Hudson and Mark, the court acknowledged a woman's equitable interest in her home despite her having transferred legal title to her lodger under the Land Registration Act 1925, thereby safeguarding her from the claim made by the third party. So under the new regime, some interests that were explicitly defined as overriding in the 1925 Act have been narrowed, making it clearer what claims will bind purchaser and if not registered. The major concern in the existence of overriding interest are the rights affecting land that may not appear in the register. So if we look at the case of Foy, the court ruled that a spouse's right to live in a family home bound subsequent purchasers. Moreover, Section 29 of the Land Registration Act 2002 permits certain overriding interest, which is contrary to the clarity the mirror principle aims to provide and can bind purchasers without their knowledge. The lack of clarity regarding the definition of overriding interest can cause inconsistencies in the application of the law. The House of Lords in the case of Abbey National Building Society and Can highlighted these problems. A purchaser may discover obligation post-transaction, leading to unforeseen expenses and complication. Misleading expectation is another issue that is faced by many buyers. Many buyers assume the register provide complete security over their interest. However, prevalence of overriding interest can result in unexpected liability post-acquisition. Such risks are also highlighted in the case of Boland, emphasizing the limitation of the mirror principle concerning equitable rights and unregistered claim. In practice, mirror principle ideals are often undermined by the realities of unregistered land and the complexities of overriding interest. So I will proceed to give some reforms to enhance the effectiveness of the Land Registration Act 2002 and address the above situation that I have discussed. I propose the following reforms. The first one is clarifying overriding interest. The Law Commission report proposed creating clearer definition around what constitutes overriding interest. The interpretation of actual occupancy is highly fact-specific, and cases like Williams and Greenbank and Boland, and also cases like Leak Lending and Bostad illustrates the complexity involved. For example, in the case of Boland rights, the court held that the actual occupation is a question of fact, leading to variability in court decision. But however, in Bostad, it was recognized that involuntary detention does not negate actual occupation if there is intent to return. These inconsistencies can lead to create uncertainty for both occupiers and purchaser. By providing detailed criteria and example regarding what constitutes actual occupation would help to ensure that all parties involved can better understand their rights and protection. Principle demonstrated in the case of Choka and Choka in 1984 which recognized temporary absence does not negate occupation, and also in the case of Foy, which clarified that lack of intent to return will negate actual occupation, will guide practitioners and court. Another reform is strengthening disclosure obligation. Introduce stricter disclosure of requirements for both purchasers and occupational claimants regarding known interest and unknown interest in land. The failure of a party to disclose an interest can undermine the rights of individual in occupation, as noted in the case of National Provincial Bank and Ainsworth in 1965. Amend the LRA 2002 to clarify the obligation of parties to disclose all known interest during property transaction with penalties for non-compliance. The third reform is mandatory registration of all proprietary interests. This requires the registration of all proprietary interests, including equitable interest and interest arising from personal rights, to protect against the loss of rights in the event of property sale. For example, in the case of City London Building Society and FLEG, it demonstrates that beneficiaries can lose their interest if a property is sold and proceedings are paid to trustee without protection of the beneficiary's right through registration. Expanding the registration requirement will strengthen the security of these interests. This reform will align with Section 32 of the LRA 2002, which ensures the protection of rights by appropriate registration. And the fourth one is to continue, this reform could also require that any equitable interest, such as equitable leases or interest arising from resulting or constructive interest or constructive trust, as established in the case of Skipton Building Society and Clayton, and also the case of Lloyd Bank and Rosette, be recorded on land registration to protect against third-party claims. And fourth is the incentivizing registration. This may include reducing fees or grants for first-time registration as outlined in the Land Registration Act 2002, Section 9, which promotes new registration. This approach was successfully advocated by the Royal Institute of Chartered Surveyor in their report on land registration reform. Fifth is public education campaign. Launching campaign to educate current and prospective landowner about the importance of registration and implication of unregistered land will empower individual. And last is utilizing technology. Let's leverage modern technology to streamline the land registration process. E-registration system and online database can enhance accessibility and reduce bureaucratic delay, which will help fulfill the goals of efficiency and transparency in the system. Initiative in other countries such as Scotland, digital land registration can serve as a successful model, creating unified and online system that allows for real-time updates of land interest, integrating electronic forms of consent and registration as laid out in the goal of the LRA 2002 Section 91. This reform will support the transition from traditional paper-based transaction to digital platform. So, to conclude, while the mirror principle within the Land Registration Act 2002 aim to enhance clarity and transparency, several practical challenges must be addressed. Each strategy that I've outlined above has its strength and can be effective on its own. However, a combined approach that incorporates elements from all these strategies will likely yield the best results. Engaging and informing landowners, making the system accessible and welcoming, and providing adequate protection will collectively incentivize higher rates of land registration. By enhancing trustworthiness and fostering a clear understanding of the registration process, the legal framework can achieve its goal of accessibility, efficiency, and transparency in the 21st century. Thank you.